Well, welcome to the legal panels here at the California Normal DPA MPP et al. Conference here. It's been quite an interesting event so far today, and so it's an important date. As you may know, the day is the date, the 8th anniversary of the United States invasion of Iraq. And I wish I had a black armband on because I still think that's a terrible tragedy. But it's interesting that 8 years after that, what we see is a full bench press against dispensaries and medical marijuana here in the U.S. by the feds. We've got the situation I'm going to talk about briefly, but one of the things that happened after Proposition 215, excuse me, was that the backers of the initiative, after it passed, kind of left the state to work on other state initiatives, and so that meant that the implementation was really done at the expense of patients and caregivers and providers who were arrested, and the attorneys who went to court to fight for their rights in the civil courts and the federal state courts and the state courts to try to defend those people. And so today it's a truly great honor on my part. I'm Conrad. I work as an expert witness in the courts, and I've worked with quite a number of the people on this panel in various capacities, and it's really an honor to be here today to introduce this group of people who have fought for patients and for general marijuana issues over these years, and here we are today to listen to them to speak. As I said, there's a few issues I wanted to bring up here that I hope the panelists will discuss to some extent. What we're going to be talking about are the initiative possibilities, legislative possibilities, and what the prospects are in the courts for getting change there. And I would like to raise a few questions here that maybe will come up in the course of the discussion, which is that if we do pass a repeal, what is it that would stop the legislature from coming back and voting in new laws? We took them off the books, but I don't know exactly how it would stop them from coming with new laws that could be equally bad, hopefully better. And the other thing is, if we do a repeal, what does that mean about local ordinances that could be prohibitive, like what we're seeing with Proposition 215 and SB 420. The localities are trying to make it so hard for patients to have their access that it essentially prohibits it. And if there's a full repeal, what does that mean in terms of that? Another question is that I would like for people to think about a little bit is, it was the Internal Revenue Service, it was a tax, the Treasury Board, that went after Al Capone during alcohol prohibition and brought him down. It wasn't the alcohol prohibition people. Similarly, the Marijuana Tax Act was actually a tax law that was prohibition in disguised as a tax law. And now today we have the IRS looking at dispensaries and collectors around the state in an effort to try to shut them down again. So what do we do about this whole federal IRS attempts to rein in our freedom by using the tax laws to do that, particularly when we want to create an environment where cannabis can be taxed? The other thing is that we have a new memo out apparently from this administration, it's a Haag or Hague memo, which seems to counter the Ogden memo. The Ogden memo, as you may recall, was in October of 2009, where the Clinton administration said they were going to stop going after medical dispensaries that were in compliance with state law or patients, or at least they suggested that it was not a good use of government resources to do that. Now we have a new memo that's come down that says that this is a core priority, is going after medical marijuana. And we've just gotten Michelle Leonhardt reappointed as the head of the DEA. So the implications of this are very important to us on a national level at least. And that brings me to the other question I think I'd like to hear a little bit from the speakers about today, which is, how do you control, regulate, and tax marijuana at state level with a federal prohibition in effect? Or is it just impossible and we have to have a federal repeal as well? So these are some subjects that I'm hoping that will get some discussion, and I know everyone has their own ideas of what they want to talk about, so I'm not going to try to interject too much from that. And let me just start off with somebody who's smiling at me very happily right now, Bill Panzer. He wanted to be last, but Matt Kumin wants to be last, so Bill gets to be first instead. Ladies and gentlemen, Bill Panzer.
I didn't really care if I was first or last. I just said that when I heard that Matt wanted to be last. Just really quickly answering your question, what's to prevent the legislature from going back in and re-putting laws back in? The California Constitution, which says that the legislature has no authority to repeal or amend an initiative unless the initiative grants them that authority. The same rule that caused the Supreme Court to overturn the SB 420 guidelines and the Kelly decision would prevent them from, the legislature from putting in new laws making marijuana illegal if we repealed. Okay, I don't have much time, so I'm going to jump in. I've come to a couple of conclusions over the last 15 years, 16, 17 years of working in these things from the early days of the Vasconcellos bill and Prop 215, etc. And that's this. One, less than 1% of the electorate actually reads the initiative language. Maybe 20 to 25% read the summaries in the voter pamphlet. The other 75 to 80% already are for or against marijuana, it's gestalt, what they see in the TV, whatever. Okay? Secondly, this idea that we need to tailor this, to counter the arguments. People tell me, hey, if you just make it legal, they're going to say it's going to be chaos. I submit to you that no matter what an initiative says in 2012, the other side's going to say there's going to be chaos. What about the children? What about drivers? That's going to cause more drugs. They're going to say that no matter what. The reason I bring this up is I would suggest that a problem that we've made in the past is we have tailored this initiative, the language in the initiative, to getting voters to vote for it, to pass it. That's a mistake. We need to tailor it for implementation to make sure that when it passes, it does what we want it to do. Prop 19, one, with all due respect to other people here that have worked on it, it was very poorly drafted. Every single law against marijuana remained in effect unchanged except one that made it worse. Passing a joint to a 20-year-old went from being a $100 fine to a maximum $1,000 fine and 6 months in jail. I don't call that legalization. The section of Prop 19 that allowed local communities to opt out of state law and allow for production and sales would have been struck down as violating the state constitution, which says that a local community cannot opt out of general state law. But nobody intended it. Now, how many people here believe that Prop 19 may have negatively impacted on medical rights? Raise your hand if you think it was possible. Now, how many of these people think that when Richard and his friends wrote Prop 19, they intended to do that? Not nearly as many. What I suggest to you is that initiative language is like a foreign language. If you need to interpret something into Chinese, you get a Chinese English fluent person to do it. You don't stand around with a bunch of people that don't know Chinese and vote on how to make it Chinese. It doesn't work. Whatever the initiative is going to say, I certainly have my druthers what I think it should say, but whatever is going to be put out there should be run through people like criminal defense lawyers that are in courts all the time, working with the DAs, the judges, the cops, doing appellate work, knowing how the judges think, knowing how they're going to be interpreting this stuff, to make sure that the language actually accomplishes what you want it to say. Now, I want to finish up by saying I've been working under the umbrella of the Cannabis Law Institute, along with Joe Rogaway, who's a fine public defender up in Sonoma County, Omar Figueroa, many of you are familiar with Omar's work in this area, Pebbles Trippett, Dr. Frank Lucido, several other people. We've been bouncing around language since we had the meeting in Berkeley back at the end of January. We have a current draft of what we're calling the Repeal Prohibition of Cannabis Act of 2012. And basically what this calls for is a repeal of all the laws regarding cannabis, with the exception of 11360. 11360 is sales and transportation, distribution and transportation. 11360 under this would be delayed. The repeal of the sales aspect of 11360 would be delayed for 180 days. The legislature would be authorized and directed to promulgate regulations during that 180-day period. It also provides protection that your own grow, you can possess up to 3 pounds and grow up to 100 square feet, and they cannot regulate that. That is free, will be free from regulation. The initiative protects all medical rights. It gets rid of civil asset forfeiture. It bars local law enforcement from working with the feds for forfeiture purposes or any other purposes. I made about 100 copies. I'm going to drop them off at the normal table upstairs, the Cal normal table. Anyone that wants to come and grab one and read it, please do. There is, at the end of it, there's an email address. Send your comments, send your suggestions. We want to be as inclusive as we can and come up with something that I think is the brass ring. And I want to finish by saying, I want to encourage everyone, let's go for the brass ring. Let's not be too timid here. I believe that if Prop 19, with everything going against it, the way it was drafted, with people within the movement being against it, with the lack of resources and funding, being brought in the wrong conservative election, if it could do as well as it did, I think almost anything we throw up there in 2012 is going to pass unless we shoot ourselves in the foot. Now, Washington State is going to have full legalization on the ballot. Oregon's going to have full legalization on the ballot. I think California should follow suit and have full legalization on the ballot. Thank you.
Thank you, Bill. And lest I would kind of, when you know someone as well as I know Bill, you seem kind of presume people know things, but I need to tell you, he's also on the California Legal Committee, the Normal Legal Committee, the National Legal Committee, and he's also a board member of California Normal, and a defense attorney par extraordinaire. He has been involved in numerous appeals court decisions, and the National Normal Board as well. So I'm learning as we go along here about how important these guys are. And so I'll go ahead and introduce our next speaker. This is Robert Raich. Rob Raich, a lot of you may have heard of because he was the attorney who was involved in the Raich decision, which went to the U.S. Supreme Court. So he has the experience of fighting a case all the way to the U.S. Supreme Court and seeing how that plays out. And he's also been a consultant to many companies or individuals who've been working in the city of Oakland and has played a role in a lot of the progress that's happened in Oakland, including, as I recall, the passage of the original Oakland guidelines, which allowed 6 pounds and 144 plants per patient, which was then modified to 3 pounds and 72 plants. So anyway, so with no further ado, let me introduce Robert Raich. Big hand, please.
Thank you. I wanted to spend some time talking about what we can really do to achieve an initiative that would be as effective as possible, to push that ball down the field as far as possible, but to also make sure that it wins. We have a little trade-off here. None of us wants to sell out on our principles, but at the same time, we want to be sure that whatever we have wins. In that regard, one of the things we need to do is have an initiative that people can understand. On an issue like legalizing marijuana, many people already have an idea in their minds. Really, it comes down to 2 words: legalize marijuana, yes or no. It's the persuadables in between who we can get to one way or another. However, some of the people who, if you just ask them in a public opinion poll, would you support legalizing marijuana? And they'll say yes. Once you actually put initiative language before them, then they start to peel away. It's easy to do that when they're misled by newspaper editorials, when our opponents start criticizing it, when they, even their own spokesman, Prop 19, said he supported legalizing marijuana, but just didn't like this language. Of course, I don't think he would like any language. The way you can mitigate that a little is having a nice short initiative. Something so short any voter can read it and understand it. Doesn't have any trapped doors in it that people would allege might exist there. As an example, let's look at Prop 215, passed in 1996. It was pretty short, filled up about 1/3 of a page in the voter handbook. As revolutionary as it was, it really just did a couple of things. It said 2 particular sections of the Health and Safety Code dealing with possession and cultivation would not apply to people with a doctor's recommendation. That's all it did. With that little toehold, we started the entire medical cannabis industry in California. It did a few other things. It defined caregivers, that doctors won't be punished, had an unenforceable provision calling on the state and federal governments to come up with a safe and affordable distribution plan. But that's it. Now, looking back earlier to what was the original Prop 19 in 1972, it would have legalized marijuana, at least possession. Many of you may not know, in 1972 there was another initiative. It happened to be numbered Prop 19, and what it did was said that people over 18 would not be denied any right or privilege or punished for a list of activities. possession, cultivation, etc. It got 33% of the vote, which was considered revolutionary in 1972, realizing Richard Nixon was president at the time, and it indicated what a constituency we had. What it did was say that in such a short manner that it took about 1/4 the size of Prop 215. On the other hand, if you look at Prop 5 back in 2008, which initially had great support, it would have had treatment instead of incarceration. The problem with it was 21 pages of fine print in the voter handbook. It was very easy for our opponents to say there are all kinds of secrets in there, and even people who might have supported treatment instead of incarceration were just afraid about what might be hiding in there. Having been in some of the debates on that, I can tell you how some people just didn't trust all of those words. So we want something nice and short to the point. Another issue that I'd like to talk about is the age limit. Is it 18? Is it 21? Does it even talk about that? One of the things we know is that a large number of our persuadable voters are parents with children under 18. People who maybe smoked marijuana when they were in high school or college, or certainly have firsthand experience with people who do or did. But now, once they are parents, somehow something's changed. What it is, it's understandable. Their objection to hypocrisy is overrun by the primal instinct to protect their offspring. I think the way to combat that is the jujitsu move of showing them that by protecting, we protect their children by ending prohibition. I'm wearing a button right now. I'll describe it for those who are too far away. It's put out by Law Enforcement Against Prohibition, a good group. It has a drawing on it of the faces of 4 cute children, and it says, "Save the children, end the drug war." Save the children, end the drug war. We need to convince these parents that to save their children, we need to repeal prohibition. Their children will actually find it harder to get marijuana if it is regulated. And under any circumstance, no parent wants to have his child arrested. That is not good for children. I think that is the kind of argument we need to make, and avoid selling out, because I really think it's important that we not throw college students under the bus in order to try to get some additional votes. These are the people who we discovered, as I understand, from 1972, really became the backbone of our constituency. People who were energetic, were willing to volunteer, get out the vote, and encourage new voters to register, something we did not see happening too much with the 2010 Prop 19. In that regard, I think as long as we know we can get enough voters, it is really worth it for that age issue to probably stand our ground and make sure we have something that we can all be proud of for decades, indeed generations into the future. Because if we don't do it right now, it's going to be incredibly hard in 50 years to fix the mistakes we make now. Thank you so much.
Thank you, Rob. And our next speaker is going to be Hanna Dershowitz. She has worked as the general counsel to Representative Rodney Ellis of Texas, and she also worked on the Innocence Project in Texas. I think she moved in between those two things. So I'll let her clarify that when she gets up here. But basically, the way that I know her is, of course, is that she worked on the Proposition 19 campaign. And you talk about a hard job when you've got like, focus groups and polls and everyone's different language and you're trying to put it together into an integrated law that works, which I'm going to disagree with some of what I'm hearing, because I think that Proposition 19 was well written but poorly understood, as a large part as a result of disinformation campaigns that were run against it. And so anyway, my point basically though is that there's a lot involved with doing election law that people don't understand, and she has this first-hand experience and is going to be an invaluable source of information for you today. Ladies and gentlemen, Hanna Dershowitz.
Thank you. Good afternoon. Well, we were asked today to discuss what legal issues we think are things that we ought to be considering moving forward. And so I wanted to maybe talk about two issues about which there is legitimate disagreement on some fronts within the legal community that we can do something differently about next time, and that affected, at least in part, had an effect on the outcome. Maybe it didn't decide the outcome, but had an effect on the outcome this time. And those are employment and the federal-state inconsistency issue. On the employment issue, I think that that is perhaps the one area where there were actual ambiguities that were present in the drafting that would have caused there to be legal squabbles after the fact, and that while those were not the issues that were raised by the opposition making arguments about the employment issue, they were different issues. Those made us vulnerable and allowed, I think, the attacks that were made by the California Chamber and sort of turning the business communities of California and the chambers of commerce against the proposition. And so I think that those are things that we need to make sure that we clarify next time around, that we ensure that everybody understands what that does, and that the message gets out before the message can be co-opted, bastardized, and incorrectly described. Because the messages that were put out there about what Proposition 19 would mean in the employment context were very inaccurate, but it was very hard to counter them given the way that there were some vulnerabilities there. So I think that we'll need to have legal briefing that fully addresses the effects of whatever resulting language is or is not present in the next incarnation, and also line up California businesses that will discuss the need for changes irrespective of the specifics of the measure that comes to the front. On the federal-state inconsistency issue, this one we can't change the fact that if there is a legalization scheme wherein sales or any commercial activities are addressed, there will be some response from the federal government. It's not clear what that response will be. I think legally, in most of those instances, we would eventually win the day, and the federal government can't stop California from doing a lot of things that California will want to do. But there's nothing where you can tweak the language and stop there from being a federal response if California does something that causes an inconsistency with the federal law. Now, most of it, though, is the bluster, and that's really where I think we lose, and where we really need to, I think, have a different approach next time around. I think that we need to take advantage, because they win on politics and the bully pulpit, and when federal government officials parade into California and do a dog and pony show and have press conferences, and because of the resources of the campaign this time, we really were snipers on the sidelines. We weren't able to have a coordinated, aggressive and affirmative response to that in the way that would counter that bully pulpit effectively. I think that we need to take a little bit more of an aggressive legitimacy attack on the federal government and on the incredible ineffectiveness and wasteful, ineffective federal policies, and use that to our advantage so that when it comes around and we can get that message out, we have put them a little bit on the defensive. I do think that people have discussed today, and it's unclear how we're going to move forward. There may not be as much of a showdown if the proposition is stripped and doesn't include some of those provisions that would allow that response to have any legs at all. But the two wrong messages, I think, that cost us votes that came from the federal government's messages were that Prop 19 would have been ineffective, would be struck down, and that the federal government would bring a world of hurt to rain upon California if this happened. And I think that both of those things are overstated or inaccurate, and yet they were able to sway a lot of voters, and it's a message that we need to be careful, thoughtful, and aggressive about at some point. Thank you.
Thank you, Hannah. And our next speaker is going to be Allison Margolin. Allison Margolin is a well-known defense attorney as well, criminal defense attorney. She is part of the Margolin law offices here in the Los Angeles area, in the Hollywood area. And just did, was it the Friday or whatever, or Monday that you came back? I was a case, no, it's not Monday, it had to be Friday. That just last week she was able to settle a case which was headed to trial. And one of the things that a lot of us feel like is we want to have our day in court, but I tell you there's certain moments where just not going to court feels like your day. And so, without any further ado, let me introduce Allison Margolin. Allison has a few words to share with everybody about where we're going and how to get there, and get ready for this.
Hi everybody, so I'm not going to really repeat what other people talked about. I'll kind of briefly go over what I think my strategies are, but I really want to focus on kind of where we are, as Chris said, and hopefully where we can change where we're going. You know, 1996 was the beginning of this whole concept of bringing safe access of marijuana to medical marijuana patients. And the case that Chris just spoke about unfortunately exemplifies the unfortunate reality of where we are right now, which is that patients don't have safe access. They're threatened by police coming into their dispensaries. They're threatened by people robbing dispensaries because the police aren't protecting them. And just this week, the case that Chris was talking about was a really sad situation. In Los Angeles in 2010, there was and there still is a dispensary called the Higher Path Dispensary. And this dispensary is permitted by the city of Los Angeles. And in 2008, the dispensary operator was found cultivating marijuana. So I got this case, and then I immediately told the district attorney, you know, he's growing this marijuana for his licensed dispensary. The district attorney then decided to, instead of allowing us to defend him through a preliminary hearing, indict him through a secret grand jury proceeding. And he did that basically in order to prevent us from putting on a collective defense. Meanwhile, down the line, the business is struggling. They can't afford to really implement very good security features. And during the middle of this struggle where the operator is now defending himself against two felony criminal charges, cultivation and possession for sale, and struggling to even keep his place afloat, his accountant last summer got killed in a dispensary robbery. And that was Matthew Butcher, and that was actually his birthday was this week, the day that we got the dispensary owner diversion, which is basically getting his case dismissed. It happened that was the same day as the birthday of this poor guy who was assassinated basically last summer at a dispensary killing. And the reason I think this is so epitomizing where we are and how unfortunate this is that we have police who are dedicated to going after a dispensary. I have a case in Long Beach where there were 125 police officers raided 3 dispensaries. These are places that have been out in the open selling marijuana to patients for months. And yet our streets are still violent and there's not safe access. It's in fact the opposite. And I was just Googling this situation again, this case, and I was looking back at what the sheriff said at the time of this dispensary killing. And what he said was not that he felt horrible that patients weren't getting safe access, or he felt that there needed to be more of a police presence in those communities and protecting patients. He said, look at this is exactly right. Dispensaries are places where there's cash, they're lucrative businesses, so obviously there's gonna be violence. So the alternative that the district attorney, I guess, in Los Angeles wants us to have is basically to go back to the streets to get marijuana. And I think the theme of our next campaign and our next initiative, which I agree with Bill, should just be basically a repeal of all the criminal sanctions against marijuana. Although I believe even 11-360 sales right away. And my dad mentioned this idea, which I think is great, which is the idea of anybody who's ever had a conviction for marijuana having that conviction erased as part of that. And it sounds aggressive, but it's not when you talk to people about their family members who've been arrested for marijuana. When you start showing people a picture, for example, of what the Central Arraignment Court lockup looks like, a place where all defendants will go unless they have the money to bail out, marijuana or otherwise. And when you start explaining to people that this is really a human rights issue and that this is not just an intellectual discussion. There are people who are going to prison, people's parents who have to worry about them bailing out of jail, and there's also the collateral consequences of people having to become felons and further basically disengaged from the society. So my answer, like theirs, is of course full-out legalization, and I think the theme has to be this is the beginning of the end of the drug war prohibition has not just failed, it's created a huge human rights disaster with people who are in prison, and even especially here in California with 3 strikes and the implications of it, people facing 10 years for a gram of crack if you have 1 prior strike, for example, in California. So I hope that this is the beginning of the end of this ludicrous drug war and the end of criminalizing people's, what I believe, fundamental right to alter their consciousness. So I hope that this initiative is the beginning of the end of that. Thank you.
Thank you, Allison. Thank you for all that great work you fighting for patients in court as well. Now, you know, one of the things he was talking about the initiative is how to cast it in words that are going to get a lot of support from people. And one of the things that they say is that people vote their fears. And I think we all agree that parents shouldn't be afraid of marijuana, but they really should be afraid of the laws and the effect that they're having and the danger that presents to their youngsters as they grow up. And so, you know, one of the issues you hit when you talk about the medical marijuana laws here, people say legalize marijuana, the voters legalize or the legislation legalize it. But in fact, to a large extent, they didn't exactly legalize it. They gave people a legal defense. And so that gives you a defense in criminal court, but that still leaves the civil issues open, and it leaves the law enforcement a lot of ability to interpret things. And so our next speaker here, Matt Kumin, has worked heavily in the civil law area, both here and in Colorado, where he's been helping advise dispensaries as to how to set up and organize in ways that are going to put them at the least risk. Because unfortunately the dangers of these laws are they go after anybody, but you have to be as safe as you can be. And so his impressions of where we could go with this are going to be hopefully a little different because he's dealing with the civil law. So thank you. Give a big hand for Matt Kumin.
Thanks, Chris. And it's great to see everyone out here today. I did want to talk a little bit about Colorado because there are some lessons in what happened in 2010 when the legislature passed a comprehensive medical cannabis law that I think may have some lessons for us here in California. Just briefly, Colorado had a vague, but it was a constitutional amendment passed in 2000 that gave caregivers and patients a status similar to our Prop 215. They stumbled along with that for years, as we have been stumbling along both with 215 and later with SB 420. And finally, in 2010, an interesting coalition of legislators came together and passed what is really the world's only for-profit, government-licensed medical cannabis statute. And I say for-profit because that's been a critical part of what's happened in Colorado. Is they've actually recognized the reality that there's money in this, and they wanted to make sure that they got a piece of it. And so the state, with a coalition of a lot of Republican lawmakers who were behind it, passed that statute. And they put a former DEA agent in charge, and the word from the attorneys on the ground in Colorado is that the DEA has basically stepped back and basically said, go ahead and do your experiment. We're watching, but go ahead and see if you can get it under control. Now, for a lot of folks who have been listening to today talk about keeping things simple, keeping regulations at a minimum, that's probably not what you're seeing in Colorado. They've got quite an extensive list of regulations, and they have a lot of formalities that you have to go through in order to get a license from the state. You can get a license for a medical marijuana center, which is essentially a retail. Linked to that, you have to have a license for a cultivation, and then separate licenses for what they call infused product manufacturers, which is essentially edibles and other kinds of cannabis-related products. Now, one of the things that has been going on here in California is because we haven't had a lot of guidance to the local on our state law. A lot of local jurisdictions we know are coming up with their own approach to medical. This is now medical cannabis, and they have been prohibiting it, putting moratorium in, or creating de facto bans. An example of that is they'll put together like an LA County an ordinance. And, sure you can have a cannabis operation, but it's going to be done in some industrial area in the southern part of the county. Or in Albany, up north, which is a 1 square mile city in between Berkeley and El Cerrito, bordered on San Francisco Bay on the other side. And they've had all these restrictions, distance restrictions. And by the time you're done going through it all, there's nowhere to go. So one of the things that I think you want to consider if you go for either a voter initiative or a legislative initiative is to have a middle ground between what's going on in California and what's going on in Colorado. In Colorado, they have given the cities and counties the right to opt out of the state law. And in November, this past November, 109 cities and counties in Colorado voted to not allow medical cannabis in their communities. I thought that was abhorrent and unacceptable. But nonetheless, Colorado has a very strong home rule system where the local cities and counties have a lot of power. What I think you need to have in California as you go forward is a concept different than the safe access concept from a criminal and personal freedom point of view, but the concept of meaningful access, which goes more to the zoning issues. In other words, if you have the ordinance or your voter initiative or your state legislature pass a law, what you want to look at is including language that says that no city or county can pass a local statute that would deny meaningful access to medical cannabis for patients. I think if you start using that concept of meaningful access in the zoning context, you may be able to get around some of the problems that we've been having throughout these fights that we've been litigating. You know, whether it's been up, in Trinity County, up in Eureka, or all the way down in San Diego and Los Angeles and Stockton, all these places that we've been litigating. You may find that is an acceptable process, an acceptable concept. Cities and counties are very united in California. They have a strong association. We're seeing them join forces to fight us everywhere. They have the same, one of the main lawyers for the cities and counties, it's the same guy who just comes around, gets hired by all the cities and counties. He tells them that he can deal with it, and he goes around and he does it. So basically, to sum up, Colorado has some interesting lessons, and I urge MPP, DPA, and Cal Normal to look more closely at how things evolved in Colorado, because I think there's some great lessons there for us.
Well, very good. So there we have it. There's an old saying I think I got from Bill Panzer that if you put 5 attorneys in a room and ask the same question, you get 10 opinions. So we've got quite a few opinions there. Our movement is very full of opinions. And one of the things that we've seen is all over the country, every state I've been to in the past 22 years working on this issue, there's been splintering going on. So people say we like to be all united. I'm not confident that that's going to happen because I think that we just tend to disagree with each other, and that's the way it's going to go. But right now we're going to open this up for questions for you. And so since these are attorneys, I know there's a lot of people who might have questions about their particular legal situation. I would suggest you might want to actually just talk to the attorneys privately about those kinds of questions and get their business card. First off, you don't want to be saying things in front of a whole room of people that may show up in court. But second off, we've got some great resources here to get some answers. So please line up over here and let's start asking these guys. Put them on the hot seat. The attorneys are used to asking questions, so let's make them answer a few questions here, okay?
The general panel. How complicated would it be to write an initiative that did nothing more than defelonize? Take every felony and drop it to a misdemeanor and the minor misdemeanors down to infractions or altogether. Would it be very complicated or would it be simple enough for the public to understand?
It would be very simple to do. In fact, there is some legislation right now. Dave Eister, who's the new district attorney up in Mendocino County, very progressive, the most progressive DA we've had in the state since Terrence Hallinan in San Francisco. Mr. Eister is working, I believe, with Tom Amiano's office on a bill that would make cultivation a wobbler. Right now it's a straight felony so that the court could decide between a misdemeanor and a felony. Also, I know Dale Geringer on behalf of Cal Normal has been working with the legislature for quite a while to create wobblers out of some of the felonies or reduce them to misdemeanors.
I guess, I don't know if it's a question or not, I guess the concern for a lot of us dispensary owners, and it's in a lot of the panels, different panels' hands, and your guys' attorneys' hands at this point, that are trying to protect us and everything. But the repeal thing that concerns me, especially with the latest release of the Hague memo, Colorado, no one seems to be protected at this point. The DEA, the federal government, saying, "Hey, we're going to come after you. We don't give a crap." So, what happens in that 180 days? The 180 days where we repeal and we're trying to get legislation to drum up some sort of program that'll make this all work. Where I don't know, we've been going 14 years now. What makes you think that they're going to do it in 180 days?
Because they have to. They're going to be under the proposed initiative. The legislature is going to be faced with a situation where sales become illegal in 180 days, whether you like it or not.
Correct. That's state legislature, though.
And in talking with state legislators, you know, the big hump is the legalizing it. Once you get over the legalizing it, as far as coming up with regulations, they can do that, and they'll do it because they have to do it.
Will that stop the federal government during that 180 days, though, from coming in and pounding us?
The federal government, the bottom line is, if you want to stay away from federal prosecution and you want to stay out of federal court, it's real simple. Stay under the mandatory minimum amounts. If the feds come in and they don't find 100 plants or 100 kilos, they're going to do a smash and grab, they're going to leave, and that's going to be the end of it. They don't prosecute unless they can get at least that 5-year mandatory minimum out of your butt.
And if there are other attorneys who would like to address any questions, you know, feel free to jump in there. It's not a one attorney per question policy here. Susan, please.
The first panel of the morning reminded me of Alan Siegel, who gave a wonderful talk at a TED conference about simplifying legal jargon. And so I guess my question would be, have you heard of him? Have you guys, what steps are you taking to reconcile? Because I think it's fully reconcilable. The people who say we need to simplify the language and also the comprehensiveness that's needed to protect everything from cultivation to transportation. Since collectives can't move around cannabis in less than 1 pound, increments, effectively. So what steps do you guys have to deal with that?
Once you start talking about taxes, things can get complicated real quickly. If all you want to do is simply repeal penalties or repeal the sections of the health and safety code themselves, that can be done very simply and does not take many words to do that. You cannot just punt the ball and tell the legislature to do something, because that's not what an initiative is. An initiative is when the voters themselves are acting as the legislature. If the legislature wanted to change a law, it could do so on its own without the voters telling it to do so. An example, again, was that provision in Prop 215 that called on the state and federal governments to come up with a safe and affordable distribution system. Here we are these many years later, still waiting for it to happen.
Well, the language actually said it encourages.
That's true. And
their position is, okay, you encouraged us, we don't want to do it.
Absolutely. On the other hand, if what you really wanted to do was to have a full regulation system to regulate, like alcohol, for example, that would take 50 pages to do it. Tom Amiano has a bill in the legislature that would essentially do that, and it is, as I understand it, 56 pages long. It would lose as an initiative for that reason alone.
If you just do it simply in simple words, the problem is that you have, I relate this a lot to the civil rights movement. In 1954, the Supreme Court in Brown versus Board of Education ruled that separate but equal was illegal. So of course by 1955 there was no more racial discrimination in this country, right? No. You had the Southern sheriffs that didn't like that law, the Southern judges that would try and find ways around it. Well, that's what we have now. We have courts that don't like medical cannabis law, and if you give them windows through which they can, get through to impinge on rights, they'll do it. Just very quickly, anyone here familiar with the Wayman case? One of the most recent medical marijuana cases, People v. Wayman, came down last October. A gentleman out of Orange County, not far from here. Young man, 21, 22 years old, gets pulled over for DUI, and they find about a $1/4 pound in his trunk. His explanation is he lives at his mother's house. His mother doesn't want cannabis in the house. Out of respect for his mother, he keeps his medicine in the trunk. The court said that's all well and fine, but under the law, you're allowed to transport an amount reasonably related to your current medical need. You're transporting reasonably related to your future medical need. That's still illegal. You're guilty of 11-360, punishable by up to 4 years in state prison. Okay? Now, if we give them the opportunity to split hairs like that, they're going to split those hairs. That's why you can't just do simple, nice language that says, you know, do it right. It won't happen.
I think there's a difference, there's a distinction between simplicity of drafting and a philosophy of simplicity and the sheer number of provisions that are needed to accomplish your objectives. You can't just leave things out because it'll be shorter. You reminded me, the questioner reminded me of a great thing in Texas. There's a writ that is usually called in a lot of states the writ of replevin, which nobody knows what replevin means. But in Texas, they call it the writ to get your property back. So, you know, I do think that we need to always try to be clear and use plain language, and that's a philosophy in legal drafting that I absolutely support, but I don't think that we should try to shed provisions just to limit the number of provisions to make things seem simple. So, that's the difference.
Hi, I wanted to get some clarification on the age issue that was discussed a little bit by Bill and by Robert, and it's been discussed a lot lately, and I think that Washington is going with 18 for their next legalization initiative. I started marijuana reform when I was 18 and came out to college, and at the same time saw with the drinking age how I felt it was really harmful to have the 21 and the social immaturity that it created. But at the same time, the whole, if you can go to war and buy a house, you should be able to drink, that doesn't convince anyone. Everyone's fine with the 21 drinking age, it seems like. And I just came off defeating a ballot initiative, or not a ballot initiative, but a vote in Santa Barbara to ban dispensaries, and the biggest issue that I was dealing with was we have 18-year-olds who can go into dispensaries and then they come back to their high school, they're still in high school, and they're reselling pot to kids, and 18 is too young, and this is our biggest problem, save the children, kind of thing. And then people talking about 19 and 20 and these different gaps in between. So Bill, my question for you was, with this full repeal initiative text that you have, is this just no laws, so everything that you get as an 18-year-old?
It's 18.
Yeah.
It's 18, and in discussing it, what we felt was, you know what, if you make it 18, the opposition is going to say, what about the children? If you make it 19, they're going to say, what about the children? If you make it 37, they're going to say, what about the children? Okay? Placating them doesn't get us anywhere. And let's be honest, cannabis is less harmful and less dangerous than alcohol. And we felt that to the extent that you're going to lose some people, I don't know very many people who are saying, I'm for cannabis legalization, I'm going to vote for it if it's 21, but I'm not going to vote for it if it's 18. I think we may lose some votes there, but not a lot. But how many votes are we going to gain from 18-year-olds who it's their first election, who are going to go, you know what, normally I'd sit around and play my video games, but damn it, this lets me smoke. I'm going to go out there and vote. And I think we'll gain more.
Well, I agree. Despite that being the biggest argument that we faced, the ban lost 61-39, so I agree it didn't actually hurt us at all. But, and then Robert, I just wanted to hear from you also, because you never actually said any numbers. I was paying attention. Do you believe 18 is the way to go?
I believe in an ideal world, we would not even address an age limit. Instead, we would do as many countries, most countries in the world do for alcohol. And we don't have an age limit. Instead, children learn how to drink responsibly from their parents. What we have in the United States, where we've got this ridiculously high age limit of 21, almost the highest in the world, it encourages binge drinking. It encourages irresponsible behavior with respect to alcohol that can carry over into the rest of people's lives. One of the worst things that happened in this country was when that awful group, Mothers Against Drug Driving, caused us to have a de facto 21-year-old drinking age all over the country. I wouldn't want us to repeat that with cannabis. Simply because alcohol has gone down the wrong route doesn't mean we should go down the wrong route with respect to recreational marijuana either. On the other hand, I am a realist. I want something to pass. I think that if we had something that did not address the age at all, that alone might be enough to defeat the initiative. And I don't want that to happen. I think that we could probably get nearly the same numbers with 18 as 21. I'll agree with Bill on that. But I'm not aware of any actual polling that indicates what the difference in support is between 21 and 18. I think a lot of political consultants would take the idea of this thinking logically. You'll get more votes if it's 21 than 18. I don't think you get that many votes, and I would like to actually see a poll that indicates that. But you don't do the poll by asking people, what is the age? Do you like 18? Do you like 21? If you do the poll that way, they're going to say, make the age 25, make the age 55, 85. Can't ask it that way.
What about the children?
Instead, the solution, in an earlier time in my life, I actually was a public opinion poll analyst. The way you structure the poll is to have two statistically significant subsamples. Ask one sample 18, ask the other sample 21, and at that point, see what the difference in support is. Only if we got something significant then would I be willing to say, okay, let's sell out and make the age 21 instead of 18 or something like that. And with respect to political consultants, again, in that same earlier phase in my life, I was a staff member in many political campaigns all over the country. I've dealt with many political consultants. They will try to get you to snitch on your mother if they think it will get an extra vote in a campaign. I think it is for us who really understand what this issue is about, and we'll still be here working on this after the election, not to sell out on certain core principles and not to be persuaded by political consultants to do that just because they think it may be expedient.
I don't have any answers on what the right number is in terms of votes, but I think that a separate consideration from how many votes you'll get with each scheme would also be what kind of opposition would you awaken, because I think that that may be more of a crux of why the political calculus might weigh in favor of one or the other. And again, I don't know what the numbers say, I don't know what the polling says, but I think that separate from the polling about how people would vote is how people would behave in the arena leading up to the voting day.
Just one comment on this whole reliance on focus groups and polling and all that. When we drafted Prop 215, we really did not rely on focus groups and polling, etc. And the people that eventually came in with the money and backed the campaign and made it all happen, you know, they were honest when we spoke. Based on their polling and their focus groups, if they had drafted Prop 215, it would not have included cultivation. There would have been no cultivation at all if they had drafted 215 based on the polling. So consider that. And again, I get back to we need to reach for the bracket string this time around.
All right, so we're going to wrap it up here. I actually had a question I wanted to pose myself, but I think I'm going to go ahead and pass on that because of the time here. I would just like to remind people that right now, as I said, it's 8 years since the United States invaded Iraq, and there's hardships going on terribly related to that. We've got Libya right now, the people getting bombed there. We have Japan with the nuclear radiation and the tsunami. So there's big problems in the world that need our help, but there's a problem that we can do something about, and that's the problem of marijuana prohibition. And that's what brings us into this room today.